Imagine you just sold your tech startup for, I don't know, $10 million.
Sounds like a pretty good day.
Right. You've spent years grinding, sleeping under your desk, pouring literally everything you have into this company.
Yeah, you've earned it.
Exactly. So the paperwork is signed, the champagne is popped, and you think, you finally made it.
Which is what anyone would think,
Yeah,
honestly.
right. But then, a year later, the buyer comes knocking. And because of a single, incredibly boring sentence buried on, like, page 87 of the contract.
Oh, no.
Yeah, a sentence you totally skimmed over because it just looked like standard legal jargon. Well, because of that sentence, they are legally allowed to claw back $5 million of your payout.
Ouch. Yeah, that is a nightmare.
And the absolute worst part, you voluntarily agreed to it. You literally signed your own financial death warrant because you didn't know how to read the negative space of a deal.
And the crazy thing is, it happens every single day.
Day.
Oh, absolutely. I mean, people assume that because a contract looks professional, because the formatting is neat and the font looks all authoritative, that it's simply a neutral record of a happy handshake.
Just a formality, basically.
Right, just a formality.
Yeah.
But when a professional deal lawyer looks at that exact same document, they see a battlefield.
A battlefield. I like that.
Yeah, they see a highly structured, deliberately engineered allocation of risk. And if you don't know how to navigate that battlefield, well, you are going to step on a landmine.
Which is exactly why we are here today. We are learning the dark arts of the fine print.
I love calling it the dark arts. It really fits.
It really does. So today we are doing a deep dive into Masterclass 5, which is called Contract Review, Negotiation, and Commercial Strategy, becoming a deal-focused drafter.
It's such a crucial topic.
It is. And our mission today is to transition you, the listener, from someone who just merely reads a contract into a strategic professional who actually knows how to deconstruct it.
Finding those hidden traps.
Exactly. Finding the traps and rewriting the rules of the game to protect yourself.
It's all about moving from passive consumption to active strategic engagement.
Yeah.
Because, I mean, you cannot just accept the board as it's presented to you.
Right, you have to play the game. So our primary source guiding this entire discussion is the highly acclaimed text, Drafting Contracts: How and Why Lawyers Do What They Do by Tina L. Stark.
A phenomenal resource, truly the gold standard.
Yeah, and we were looking specifically at the methodologies of reviewing contracts, amending them, and using this really fascinating 5-prong framework to extract and add massive commercial value to any deal.
Which is where the real magic happens.
Okay, let's unpack this, because I have a question right out of the gate. If drafting a contract from scratch is widely considered to be an incredibly difficult task, which, obviously it is, why do seasoned lawyers argue that reviewing someone else's draft is actually significantly harder?
That is a great question. And the answer is because reviewing a contract requires you to perform essentially a psychological and structural reverse engineering.
Reverse engineering. Okay, tell me more about that.
Well, think about it. When you draft a contract from scratch, you have a blank page. You know exactly what your client's business goals are, and you build the architecture, brick by brick, to support those goals.
So you know where all the pipes are hidden, basically.
Exactly. You know where all the load-bearing walls are. But when you are reviewing the other side's draft, you're staring at a completely finished building.
Right.
And your job is to figure out where the opposing architect deliberately hid the structural flaws. Or worse, where they set traps specifically designed for you to fall through.
Wow. Okay, so a provision might look completely reasonable on its face. Like, the language is smooth, it reads well, there are no typos or anything.
It looks totally harmless.
But as the reviewer, I have to figure out what the original drafter is trying to hide, or what risk they are quietly shifting onto my side of the ledger. It kind of feels a bit like, I don't know, being a home inspector looking at a freshly painted wall and having to deduce if there's black mold growing behind the drywall just by looking at the paint job.
That is a perfect analogy. Honestly, that hits the nail on the head. You have to ask yourself, why did they choose this specific word instead of a slightly different one?
Because it's never an accident.
Never. In a commercial contract drafted by a competent lawyer, every single choice is deliberate. There are absolutely no accidents.
Okay, so to catch those deliberate choices, the source material lays out this highly systematic 5-step professional review process. Because you can't just dive in and start crossing out words.
Oh, definitely not. If you just start crossing things out, you're going to make a mess. You need a system.
Let's break down that system. The first step the Masterclass outlines is to simply understand the transaction. Which, on the surface, sounds incredibly basic. Like, obviously, you need to know what the deal is. But the text treats this as a profound prerequisite.
It is profound. Because if you do not understand the underlying commercial reality of the industry, the specific players and the mechanical flow of the actual business deal, you aren't lawyering.
What are you doing, then?
You're just proofreading for grammar.
Wow.
Yeah, I mean, you have to know how the machine operates in the real world before you can regulate it on paper.
Okay, give me a tangible example of that. Like, how does failing to understand the industry ruin the review process?
Okay, the source material uses this brilliant example regarding the jewelry industry.
Oh, I remember this.
Yeah. So imagine a bank is lending money to a jewelry manufacturer. The bank wants to take a security interest in the manufacturer's inventory.
Meaning, if the manufacturer defaults on the loan, the bank can seize the diamonds and gold to get their money back.
Exactly. Basic collateral. Now, if you are a lawyer who doesn't understand the jewelry business, you might draft or review a standard security agreement and think your client, the bank, is fully protected.
Because you check the box that says secured inventory, but they aren't protected.
They aren't protected at all because the jewelry industry operates on a very unique system called memo.
Memo, like a memorandum.
Right. Manufacturers constantly give retailers jewelry on consignment. They hand over literally millions of dollars of inventory to a store without any formal legal filings, just a memorandum.
Oh, wow. So the physical goods are just out there.
Yes. If you, the reviewing lawyer, don't know that this is how the physical inventory moves in the real world, you won't know that your standard security clause is completely useless.
Because the inventory you thought you secured is actually sitting in 50 different retail stores across the country, completely undocumented.
Exactly. You have to know the business reality before you can evaluate the legal reality.
That is terrifying. Okay, so step one is becoming a mini expert in whatever business your client actually does. Got it. So once I know how the physical diamonds move, what is step two?
So step 2 is to identify the commercial objectives.
Okay.
This is all about aligning the legal document with what your client actually wants to achieve, not just what the law allows them to do.
Right, because those can be two very different things.
Exactly. Say you are representing a software developer licensing their code to a massive corporation. What is their primary objective?
I mean, it could be a few things, right?
Right. Is it getting a massive upfront payment? Is it securing a long-term royalty stream over a decade? Or is it retaining the intellectual property rights so they can turn around and sell the same code to someone else?
And if you don't know which of those it is?
If you don't define the objective, you might negotiate aggressively for, say, a higher royalty rate, but completely miss the fact that the contract forces your client to surrender the underlying IP.
Which was actually their most valuable asset.
Exactly. You won the battle, but lost the war.
Wow, so it's about defining what a win actually looks like for the person paying your bill.
Precisely.
Which leads directly into step three, identifying the risks. If step two is figuring out what we want, step three is figuring out what could destroy us.
That's a great way to put it. And risk is, it's multifaceted. It's not just, well, what if they don't pay?
Right, it's bigger than that.
Much bigger. It's credit risk.
Right.
Does this company actually have the capital to survive a market downturn? It's regulatory risk. What if the government changes the environmental standards halfway through this construction project? Or performance risk, like what if their key engineer quits?
So you have to be super paranoid?
The reviewing lawyer has to catastrophize. You have to imagine literally every possible way the deal could explode and then look at the contract to see who takes the shrapnel.
Man, I imagine this is where the friction really starts in a negotiation, because if I represent the buyer, I want all the risk on the seller. And if you represent the seller, you want it all on me.
Right, nobody wants to hold the bag. And that tension, that's what gets resolved in step 4, reviewing the obligations.
Okay, so mapping out who does what.
Right. Once you know the risks and the objectives, you meticulously track the mechanics of performance. Who has to do what, by when, and to what standard?
Can you give an example of how that looks in practice?
Sure. If the contract says the seller must deliver the goods, quote, promptly.
Yeah, that sounds pretty vague.
It is incredibly vague. As a reviewer, you have to tighten that obligation to protect your client's objective. So promptly becomes, say, within 48 hours of written notice.
Okay, so you're pinning them down.
You're crystallizing the mechanics so that if the deal does explode, there's absolutely no ambiguity about who breached the contract.
Which brings us to the final step of the professional review process. Step 5, suggesting amendments. And this is where we actually change the game.
This is the fun part.
Yeah, and the Masterclass introduces a concept here that completely reframes how I view this entire profession. The mantra among deal lawyers is, a deal lawyer eats what she kills.
It is a ruthless phrase,
It really is.
but it captures the absolute essence of contract review. Look, if you represent the listener, if they're your client, and you read the draft provided by the opposing counsel, and you certainly say, well, the grammar is fine, the clauses look standard, looks good to me, you starve.
Because you didn't do anything.
You provided zero value.
Because the opposing counsel didn't write it to be fair, did they? They wrote it to win.
Exactly. The original drafter represents their client, not yours. That draft naturally, inherently, and sometimes very ruthlessly favors their client's commercial objectives. And it shifts the risk onto you.
So everything they left out is a weapon.
Yes. Every missing protection, every subtly shifted liability, every vaguely worded standard, like a promptly example, those are all issues you have to hunt down.
You have to find them to survive.
Every single issue you identify and drag out into the light is a kill. It is a point of leverage that you have successfully brought to the surface, which you can now use to negotiate and protect your client.
If you don't find them.
If you do not find those points, you have surrendered your negotiating leverage without firing a single shot.
Wow. Okay, but this raises a really important question. If I am looking at a 150-page commercial lease or, I don't know, a massive merger agreement, the sheer volume of legalese is paralyzing.
It is intimidating for sure.
If I have to hunt for these kills across hundreds of pages, how do I even know where to begin? Like, do I just grab a giant cup of coffee and start reading page 1, line 1?
That is the worst possible thing you can do.
Really?
Oh, absolutely. You do not read a contract like a novel from start to finish. You read it tactically. The source material outlines specific phases for how a master reviewer physically approaches a massive document.
Okay, tactical contract reading. I like the sound of that. Phase 1 is what the Masterclass calls eyeballing or getting your bearings. This isn't just skimming, though, right?
No. Eyeballing is a structural analysis.
Yep.
You are looking at the architecture of the document. You go straight to the table of contents.
What am I looking for there?
You're looking to see how it's built. Is the contract organized chronologically, following the life cycle of the deal? Or is it organized by subject matter? Does it look like a standard industry precedent, something you've seen 100 times before? Or has the opposing drafter invented a completely novel structure?
But why does that actually matter? If the words are the same, who cares if they move the sections around?
Because a novel structure is often a hiding place.
Oh, tricky.
Very tricky. If a lawyer abandons the standard industry form, they're usually doing it because the standard form didn't give their client a specific advantage they wanted.
So they shuffle the deck to hide the bad cards.
Exactly. When you eyeball the document and notice that, say, the indemnification clause has been moved out of the standard remedies section and it's buried inside a miscellaneous section at the very back of the book, your alarm bells should be ringing.
You map the terrain so you know where the traps are most likely to be set. That is fascinating. You're analyzing the metadata of the document before you even read the text.
It saves you so much time and pain later.
I bet. So once you've mapped the terrain, we move to phase 2, the key business provisions. And the source points out something very true about human nature here.
Oh, the 5-minute rule.
Yes. When a client calls you 5 minutes after you email them a massive contract, they don't want to talk about the severability clause or, the choice of law provisions. They care about two things, the money and the end game.
And as the reviewer, those are the first two things you must read. The money and the end game are the pulse of the transaction.
So you jump straight to the numbers.
You look at the money first. Are the payment terms right? Is the purchase price what the parties actually agreed to in their handshake? And then you look at the end game. How do we get out of this if it goes horribly wrong?
Right. When can the other side sue my client? Or when can my client terminate the deal and walk away?
Exactly. If you understand the money and the end game, you understand the core commercial reality of the draft. Everything else in the contract, honestly, is just scaffolding to support those two concepts.
So I've mapped the structure, I've checked the money, I've checked the exit strategy. Only then in phase 3 do I actually read the rest of the contract.
Right.
But again, the text explicitly says you still don't read it chronologically. You use a technique called provision hopping.
Provision hopping mimics the way the contract was actually built.
How so?
Well, a contract is not a linear story. It is a highly interconnected web of logic. Let's say you are reading Article 4, which outlines your client's obligation to deliver a software product.
Okay.
You can't just read Article 4 in a vacuum. You have to hop back to Article 1 to read how the term software product is actually defined.
Because capitalized words are basically their own mini contracts.
Exactly. And then you have to hop forward to Article 9 to see what the penalty is if the delivery is late. You review related provisions at the exact same time to see how the gears mesh together.
That makes total sense. Now, here's where it gets really interesting, I think. The Masterclass highlights a critical insight that separates the amateur reviewers from the absolute masters. Amateur reviewers only look at the words on the page. They analyze what is there. Master drafters look for what is missing.
Spotting the negative space. It is the hardest skill to develop in this entire profession.
I can imagine.
It is relatively easy to argue over whether a notice period should be 5 days or 10 days. The words are right there. But it's entirely another level of skill to realize that the opposing drafter conveniently left out your client's right to terminate the contract if the other party goes bankrupt.
Because there are literally no words on the page to trigger your brain to think about bankruptcy.
Exactly. Finding the invisible gaps requires you to hold the entire, ideal, perfect version of the deal in your head and then constantly compare it against the flawed, biased version sitting in front of you.
That is heavy mental lifting.
It really is. If you are reviewing a joint venture agreement, for example, and there is no clause detailing how the parties can force a buyout if they end up hating each other, the amateur thinks, oh great, fewer pages to read.
Less work for me today.
Right. But the master realizes, wait a minute, they deliberately left out an exit strategy so my client will be trapped.
You have to see the silhouette of what they deliberately cropped out of the picture. That is brilliant.
It's the hallmark of a great lawyer.
Okay, so let's say I've done all this. I've eyeballed the structure, I've hopped through the provisions, I've found the missing clauses, and I've got a pile of, kills on my desk. How do I actually translate those findings into commercial value for the listener? How do I fix it?
This is where we bring in the heavy machinery.
Right. The Masterclass introduces what I think is the most powerful tool in the text, a 5-prong commercial framework. Elite dealmakers use this exact lens to view every single transaction. The 5 prongs are money, risk, control, standards, and endgame.
If you master this framework, you stop being a proofreader and you become a strategic advisor. It is transformative.
Let's start with prong 1, money. Because when we talk about money in a contract, we are rarely just talking about a static, flat purchase price, right?
Yeah, rarely. We're usually talking about the velocity of cash, the timing of payments, and, most dangerously, the mathematical formulas used to calculate future payouts.
The text gives a deep dive into earnouts that perfectly illustrates this. So for you, the listener, an earnout is a pricing structure really common in selling a business. Let's say you are selling your startup. The buyer says, I'll give you $1 million in cash today and another $1 million next year, but only if the company hits certain financial targets.
Sounds great on paper.
Sounds awesome, right?
Yeah.
But whether that formula is based on bottom-line net profit or top-line gross revenue changes absolutely everything.
This is where accounting becomes a weapon, and the reviewing lawyer must understand it.
Okay, explain how that works.
If your client, the seller, takes $1 million up front and leaves the company, they no longer control the accounting, right?
Right. The new guys are running the books.
So if you agree to an earnout based on bottom-line net profit, you have just handed the buyer a loaded gun.
Wait, why? Net profit just means the money left over after expenses. That seems totally fair. If the company makes a profit, I get a cut.
It seems fair until the new buyer suddenly decides to give all their executives massive bonuses.
Oh.
Yeah. Then they buy a fleet of brand new company cars. Then they hire a consulting firm owned by their cousin for exorbitant fees. Suddenly, the administrative expenses have absolutely skyrocketed.
And the profit disappears.
The company might be making tons of money from customers, but on paper, the net profit has been artificially reduced to zero. And because the formula said your client only gets paid based on net profit, they get absolutely nothing.
They legally hid the profits behind inflated expenses to avoid paying me. That is diabolical.
It happens all the time. So how do you use the money problem to add value? If the other side controls the accounting, you must aggressively amend the contract to demand a top-line gross revenue formula.
Because they can't fake the gross revenue.
Exactly. It is incredibly difficult to manipulate top-line revenue. Money either came in the door from customers or it didn't. You can't expense it away.
Wow.
Conversely, if your client is the buyer and they control the accounting. You want the bottom line formula to protect yourself from paying out a bonus on revenue that wasn't actually profitable.
That completely flips my understanding of how to read a financial clause. You aren't just checking the math, you are anticipating human behavior and greed.
Human nature is the biggest variable in any contract.
Let's move to prong 2. Risk. The text states that a client's risk aversion profile dictates everything.
Risk is, honestly, the dark matter of contracts. It is everywhere.
Credit risk, tort liability.
Regulatory risk, supply chain failure. A strategic drafter uses specific legal tools to mitigate and shift that risk. And the two most vital tools are representations and covenants.
Yeah.
And the difference between them is absolutely critical.
Break that down for the listener. What is the actual difference? Because I feel like a lot of people use those words completely interchangeably.
They do, but legally, they are worlds apart. A representation is a statement of past or present fact. It is a snapshot in time.
Okay.
Like, I represent that the roof of this warehouse does not currently leak.
Okay, so it's a fact about right now.
Right. If it turns out the roof does leak, you lied. You have made a misrepresentation. The legal remedy for that is often incredibly severe. I can sue you for fraud, or I can unwind the entire contract as if it never happened because I entered into the deal based on a lie.
Wow. Okay, so a representation is about the state of the world right now, and the penalty is massive. What is a covenant?
A covenant is a promise to do something or refrain from doing something in the future.
So future tense.
Right. I covenant that I will fix the roof by next Tuesday. If Tuesday comes and goes and you haven't fixed the roof, you haven't committed fraud.
Because it wasn't a lie about the past.
Exactly. You have simply breached a contractual promise. I can't necessarily unwind the entire deal. I can only sue you for the specific monetary damages caused by the unfixed roof.
Which might be way less money.
Much less.
So if I want to shift maximum risk onto the other party, I don't just want them to promise to do things in the future. I want them to make hard, factual representations about the present, because the penalties for lying are so much higher.
Precisely. If your client is highly risk-averse, you hunt down all the weak future covenants in the draft and rewrite them as hard, present-day representations. You force the other side to absorb the financial hit if their snapshot of reality is wrong.
That is an incredible distinction. Just swapping those concepts changes the whole risk profile. And that bleeds perfectly into prong 3, control. Who actually gets to decide how the risk is managed? I like to think of this with a real estate analogy. It is the fundamental difference between a developer promising you that they will secure an environmental permit versus promising you that they will fill out the paperwork in good faith.
That is a classic high-stakes control issue.
Yeah.
If the contract forces you to promise that you will obtain the permit, you are taking on the risk of an unpredictable third party, in this case, the government agency.
And nobody controls the government.
Exactly. You do not control the government. If the agency capriciously denies the permit for no good reason, you are in breach of contract. The other side can sue you, and you have absolutely no defense because you guaranteed an outcome you couldn't control.
So how do I use the control prong to rewrite that and protect myself?
You step in and change the nature of the obligation. You amend the text to say the developer will use commercially reasonable efforts to obtain the permit.
So you're just promising to try really hard.
Right. By doing that, you align your client's legal obligation with their actual real-world level of control. If the government denies the permit now, your client isn't sued because they fulfilled their promise. They tried their best.
You stop letting the client gamble their entire business on the whims of a third party.
Exactly. You insulate them.
Which brings us to prong 4, standards. Or, as I like to call it, the terrifying power of adjectives.
The terrifying power of adjectives is exactly right. Words have immense kinetic energy in commercial drafting. Every single descriptive word establishes a standard of liability.
The source text uses this seemingly mundane example that actually dictates millions of dollars. It's just changing the word acceptable to reasonably acceptable.
It's a huge shift.
It's one adverb. Most people reading a contract wouldn't even blink at that. How does one word change the universe of a deal?
It changes the entire power dynamic of who gets to kill the deal. Imagine you are a custom software developer. You spend an entire year building a massive platform for a client. The contract drafted by the client's lawyer says the final software must be, quote, acceptable to the buyer. That is a subjective standard.
Right.
The buyer can look at the software, decide they don't like, the specific shade of blue you used on the login screen, declare it unacceptable, and completely refuse to pay you. They have total absolute discretion.
Because acceptable to me means whatever I want it to mean in that exact moment.
Yes. But as the reviewing lawyer, you use the standards prong. You cross out acceptable and write reasonably acceptable.
Okay, so what does adding reasonably actually do?
You have just injected an objective third-party standard into the transaction. Now, if the buyer wants to reject the software over a shade of blue, they can't just rely on their own whim. If they refuse to pay and you take them to court, they have to prove to a judge that a reasonable person in the software industry would also find that shade of blue unacceptable.
Which they probably couldn't do.
Exactly. You have completely stripped them of their arbitrary power.
One adverb protects the client from a capricious, bad faith buyer. That is wild. All right, the final piece of the framework. Prong 5. Endgame. Every contract ends. Sometimes it's a happy ending where everyone makes money, and sometimes it's an absolute disaster.
What's fascinating here is the psychology of the parties. Clients rarely want to think about the unhappy ending.
Of course not.
They are in the honeymoon phase of the negotiation. They are popping champagne, talking about synergies. But the reviewing lawyer must be the ultimate pessimist. You have to map out the divorce before the wedding even happens.
The source material gets very granular about this. We have to meticulously track the monetary consequences of termination. Like if there is a default, who pays for unwinding the mess? And the text brings up a critical distinction here regarding remedies. It asks, are common law remedies preserved, or are the contractual remedies exclusive? Can you explain that for the listener who didn't go to law school?
Absolutely. So when a contract is breached, the common law, which is essentially centuries of legal precedent decided by judges, automatically gives the wronged party certain rights. Usually the right to sue for standard financial damages.
Okay, so that's the default background law.
Right. But in a contract, you can write specific contractual remedies, like a liquidated damages clause that says, if you are late, you owe me exactly $1,000 a day, or a right to seize a specific piece of equipment.
So you have the judge's default rules and your custom rules.
Exactly. The trap is when the opposing drafter slips in a clause that says, the remedies described in this section shall be the exclusive remedies of the parties.
Oh, exclusive, meaning only these custom ones apply.
Yes. If you don't catch that, you have just waved goodbye to all your common law rights. If they breach the contract in a bizarre way that you didn't specifically anticipate in your custom remedies, you can't go to the judge and ask for standard damages. You are locked out.
Wow.
The endgame prong demands that you protect your avenues of recourse. You must strike the word exclusive.
I want to take all of this, the negative space, the reverse engineering, the 5-prong framework, and actually put it to the test. Let's do a practical exercise.
Let's do it.
The Masterclass source material provides a fantastic scenario involving an employer receiving proposed amendments from a contractor on a major construction project.
This is where the theory hits the pavement.
Let's set the scene for you, the listener. You are representing the employer. Your client is the one with the money, paying for a massive new office building to be constructed. You send over a tough, protective contract. The contractor's lawyer just sent back a heavily marked up draft with major amendments. They want changes before they start digging. Let's run their demands through our framework. First up, payment changes. The contractor crossed out your milestone schedule. They want significantly more money up front before major work is actually completed.
The moment you see that, you trigger the money and control prongs. Why do they want money up front? Usually it's to fund their own working capital so they don't have to take out a loan.
Right, they want to use my client's money to float their business.
Yeah, exactly. But look at what it does to your control. If you pay the contractor 80% of the total budget when they've only poured the foundation, you have lost all your leverage.
Because if they walk off the job, I've paid for a whole building and only got a hole in the ground. I'm totally underwater.
Exactly. The purse strings are your ultimate mechanism of control. If you fund them ahead of their actual performance, you absorb massive credit risk. You have to use the framework to balance their legitimate need to buy materials with your absolute need to hold back enough cash to incentivize them to actually finish the roof.
Make them earn the payout. Okay, next amendment. Extension of time provisions. In your original draft, you had a very strict clause regarding delays. The contractor crossed it out and replaced it with a single sentence. The contractor shall complete the work within the period, subject to reasonable extensions.
That is a massive, screaming red flag under the risk and standards prongs. The source text explicitly warns against accepting weak clauses like this.
But what makes it weak? It says reasonable. We like that word, right? We just used it to save the software developer.
We like reasonable when we are defending against a subjective standard. We hate it when it gives the other side a blank check.
Ah, okay.
A strong extension of time clause is highly mechanical. It requires specific notice. The contractor must notify the employer in writing within 48 hours of a delay event.
So no claiming delays 6 months later.
Exactly. And it requires an assessment mechanism. The contractor must prove mathematically that the delay actually impacted the critical path of the project.
Let's define that for the listener. What is the critical path?
In construction, the critical path is the specific sequence of tasks that determines the absolute minimum time needed to finish the project. If a task on the critical path is delayed, say, pouring the foundation, the entire project opening is delayed.
Right.
But if a non-critical task is delayed, like painting a secondary stairwell, the building can still open on time.
Oh, I see. So if it rains and delays the painters, the contractor might demand an extension under their weak reasonable extensions clause, even though the delay didn't actually push back the grand opening.
Exactly. By stripping out your mechanical requirements, they are shifting all the schedule risk back onto your client. You must reject their vague standard and force them back into a strict, verifiable process.
All right. The final amendment from the contractor, and this is the one that really gets me. Liability limitation and termination rights.
This is always a battleground.
Yeah. The contractor inserts a new clause capping their total liability at 10% of the overall contract value. And they add a right to terminate the entire contract if an invoice is late by just 3 days.
Wow.
Let me push back here. If I'm reviewing this and I see they are trying to cap their liability at 10%, aren't they acting in bad faith? Like, if they burn down my half-finished building through sheer incompetence, why should I compromise with a party trying to pull a fast one? Shouldn't I just reject all of it? Send the draft back with a giant red NO across the front?
That instinct is incredibly common, and it is exactly what differentiates a litigator from a deal lawyer. A litigator looks at a conflict and wants to win the argument. A deal lawyer looks at a conflict and wants to close the transaction safely. If you just scream no and reject their markup entirely, the contractor walks away. They take another job.
And my client has no building.
Exactly. Your client, who desperately needs this office building built, gets nothing. You've failed your client.
But I can't just accept a 10% cap. That's financial suicide for my client.
I agree. You absolutely cannot accept it as written. This is where strategic problem solving comes in. You bridge the gap by identifying their underlying fear and giving them a safe harbor without surrendering your client's core protection.
So why do they want the cap?
Because they're terrified of a freak accident bankrupting their entire company.
Okay, so how do we compromise without giving away the farm?
You carve out exceptions. You use the control and endgame prongs. You go back to them and say, we will accept the 10% liability cap for ordinary, everyday negligence.
Okay.
However, the cap does not apply to gross negligence, willful misconduct, or any damages covered by your insurance policies.
Ah, so if a worker drops a hammer and breaks a window, they are protected by the cap. But if the foreman decides to light a bonfire in the lobby and burns the place down, the cap evaporates and we can sue them for everything.
Exactly. You manage their legitimate fear of minor mistakes while preserving your client's right to full remedies for catastrophic failures.
That is so smart.
And regarding their demand to terminate if a payment is 3 days late, that is far too short. An administrative banking error or a holiday weekend could blow up a multi-million-dollar project.
So we reject that.
You don't reject the concept of termination. You negotiate a cure period. You amend it to say the contractor may terminate if payment is delayed, provided they give 15 days written notice, giving the employer an opportunity to cure the default. You solve the problem by engineering a safety valve.
This is brilliant. You are literally reshaping the reality of the business relationship.
That's the job.
So we've reverse engineered the contract, we've applied the 5-prong framework, we found the invisible missing pieces, and we've figured out exactly how we want to compromise. Now comes the execution. How do we physically communicate all these demands to the other side?
Execution is everything.
The source material outlines a few different methods. You can make oral comments on a phone call, you can write a descriptive memo, or you can do a physical markup of the contract itself.
And while a phone call might seem the most direct, just hashing it out, the text makes it clear that doing a physical markup, literally redlining their document, crossing out their words and inserting yours, is the ultimate strategic power move.
I always thought redlining was just an administrative chore. Why is it a power move?
Because of the deep psychology of negotiation. If you sit in a glass conference room with both clients present, and you verbally demand that the opposing lawyer change their liability standard from subjective to objective, you are attacking their work in public.
Oh, I see.
Egos immediately get involved. The opposing lawyer has to defend their draft so they don't look weak or incompetent in front of their client. They will fight you on principle alone.
They dig their heels in just to save face.
Exactly. But if you send a written, highly detailed red line markup, you change the environment entirely. It allows the other side's lawyer to review your demands quietly, alone in their office.
Without an audience.
Right. They can look at your changes, realize you caught them trying to slip a subjective standard past you, and they can silently concede the point without losing face in a live meeting. You give them a safe space to retreat.
You let them surrender privately. That is, wow. That is Jedi mind trick level strategy.
It's just human nature.
But the text also warns that doing a markup is incredibly dangerous for the reviewer if they aren't meticulous because of a phenomenon called the cascade effect.
Yes, the cascade effect is the hidden danger of all amendments. As we discussed earlier, contracts are not linear, they are interconnected ecosystems.
Right, the provision hopping thing.
Exactly. Let's say you were representing a client selling their business. In Section 1, you successfully negotiate a change to the defined term revenue so that it explicitly excludes certain state taxes. You feel great. You got a kill.
Unprotected the money.
But you failed to track the cascade effect. What you didn't realize is that the defined term revenue is also used deep in Section 15 as part of a mathematical formula to calculate a massive termination penalty if the buyer defaults.
Oh.
By changing the definition in Section 1 to solve one problem, you accidentally broke the math in Section 15. The formula no longer computes properly, and now, if the buyer defaults, the termination penalty is mathematically impossible to calculate.
Oh my God. I fixed a leak in the kitchen sink, but the pressure backed up and flooded the basement.
That is exactly what happened.
So I have to meticulously cross-reference every single instance of a word I change. That sounds exhausting.
It is exhausting, but it's the only way to protect the client.
Now, let's unpack one final, highly technical piece of strategy the source provides. The difference between an inside the contract amendment and an outside the contract amendment. If I'm understanding the text correctly, an inside amendment is surgical. It specifically targets the literal words on the page. Like in Section 4, line 3, delete the word 5 and replace it with 10.
Correct. It is precise. It acts as an instruction manual telling the reader exactly how to physically alter the underlying document.
But an outside the contract amendment doesn't target specific words. It is a separate side letter that just states the broad effect of what the parties want. It might say, notwithstanding anything written in the main 100-page agreement, the parties agree that all notice periods are now 10 days. That sounds so much faster and easier than hunting down every instance of the word 5. Why does the Masterclass say this is bad?
Because taking that shortcut today invites catastrophic litigation tomorrow. Outside amendments are fundamentally sloppy.
How so?
Imagine 5 years from now, a dispute arises. You and I are no longer involved. A judge or an arbitrator has to look at this deal. They read the original 100-page contract, and they see 3 different notice periods in different sections governing different events. One for payment default, one for environmental issues, one for structural failure.
Okay.
Then they read your vague side letter that says, all notice periods are 10 days.
Oh, no. I see where this is going.
Exactly. The judge has to guess what you meant. Did you mean to overwrite the payment default notice? Did you mean to overwrite the environmental notice? The side letter conflicts with the specific mechanics of the main text.
Because I was too lazy to do the surgery.
By refusing to do the surgical, inside the contract work of changing the specific words, you left the interpretation up to a stranger in a black robe 5 years later. You saved yourself 3 hours of transaction time, but you created $1 million liability for your client.
So what does this all mean? The overarching theme here is that precision is protection.
Precision is absolutely protection.
Let's summarize this journey we've been on. For you, the listener, the next time someone slides a piece of paper across a desk, or more likely, sends you a DocuSign link, reviewing it will never be the same.
I hope not.
You are no longer just looking at a digital handshake. You now have the 5-step professional review process. You understand the necessity of learning the commercial reality, identifying the risks, and eating what you kill. You know how to tactically read a document, eyeballing the structure, skipping straight to the money in the endgame, and provision hopping to see how the gears mesh together.
And looking for what isn't there.
Yes. You know that the hardest skill is finding the negative space, the missing exit strategies. You have the five-prong commercial framework: money, risk, control, standards, and endgame, to evaluate and rewrite every single clause to protect your own interests. And you understand the psychology of the markup and the hidden dangers of the cascade effect.
If we connect all of this to the bigger picture, moving from someone who merely signs contracts to a strategic professional requires a fundamental shift in perception.
Tell me about that shift.
You must realize that a contract is not a static historical record. It is a living, breathing allocation of risk. It is a piece of machinery designed to produce specific commercial outcomes in the real world. And armed with these tools, you have the power and really the absolute responsibility to mold that machinery to protect yourself and your business.
A living, breathing allocation of risk. I love that.
Mm.
Which brings us right back to where we started today. I want to leave you, the listener, with a final thought to mull over.
A provocative one, I hope.
Always. Think about the last standard agreement you signed in your own life. Maybe it was an employment contract for a new job, a massive software terms of service for your company, or a commercial lease. You probably assumed it was just boilerplate language, right? A standard form everyone signs.
Most people do.
But based on what we explored today about the mindset of a deal drafter, about eating what you kill and reverse engineering the architecture, what invisible risks did that original drafter successfully hide from you? What massive liability was quietly shifted onto your shoulders simply because you only looked at the words that were printed on the page instead of hunting for what was deliberately left out?
It really makes you wonder.
It's enough to make you read the fine print next time. Thanks for joining us on this deep dive. Keep questioning the negative space, and we'll see you next time.